So welcome to the second part of the Perplexed Parent Stress Student Guide to the Tort Law paper. This is where we left off in the last video, so moving on then. The next basic idea to grasp is duty of care, which is to establish a legal relationship between the defendant and the claimant so that a claim could be brought. So a duty of care then is first established by the neighbour principle in the case of Donoghue and Stevenson. And a duty of care is the responsibility we have to ensure that others or their property are not damaged by our irresponsible actions. So the torts there are essentially to protect our interests in ourselves and in our property in civil disputes. And that's so the state doesn't have to pick up the pieces or financial costs for every accident that happens. So the neighbour principle says we should have regard for anyone who might be harmed by what we do or what we fail to do, and that's called an omission. This was further developed in the case of Caparo V Dickman and established what was called the three-part Caparo test, which is a disputed idea in law, but we don't need to deal with that right now. So the Caparo test asks three questions. Was the damage or harm reasonably foreseeable? Was there a sufficiently close relationship between the defendant and the claimant? And this is the word proximate. Was there a proximate relationship? And is it fair to impose a duty on the defendant? A couple of recent cases, Robinson and Steele, it's been established by the judges in those cases that what should actually happen is existing case law should be used unless there's a completely new situation, and that way we can develop the law incrementally and by analogy. So the three-part Caparo test is used as a kind of last resort. Generally, you should use existing laws and just develop them to cover the new situation. The next idea then is a breach of duty, and what needs considering here is there's an objective standard of care or behaviour that needs to be reached, and that would be the standards of a reasonable person in that occupation or in that profession. And the question to ask is, does the conduct of the defendant fall below that objective standard? But we also need to consider various risk factors. Are there special characteristics about the defendant? What was the size of the risk? What precautions were taken? Were the risks known about? Is there a public benefit in not imposing a duty of care? So again, your son or daughter should be pretty well versed in this, and do ask them to explain these ideas, because it does help if you are attempting to explain something to somebody else. It does check your knowledge and understanding. So the next idea to consider then is this notion of damage, and we want to consider two things. One is causation, and that's proven by the but for. So but for the defendant's action or omission, would the harm or damage have occurred? So that's one of the first things to establish. And the other thing to consider is how foreseeable was the harm or the damage. And the more foreseeable it was, the more likely it is that a duty of care was owed. The other thing to consider is just because the victim had some kind of special characteristics and was maybe more vulnerable to harm than the average person, you cannot use that as a defence. That's called the eggshell skull rule, or you take the victim as you find them. There are a couple of things that can reduce the amount of damages awarded or give a complete defence, so no damages are payable by the defendant. So factors like contributory negligence gives a percentage reduction anywhere from 1% up to 99%, and consent or valenti gives a complete defence. So did the defendant know what they were doing? Had they got free choice? And did they voluntarily accept the risk? Okay, moving on to the final video then.